Welcome to Legal Aspects of EMS. We started off talking about some terms. These are terms that you will need to know for your exam. Start off with assault and battery. Assault, not a pepper, assault. Assault is threatening, attempting, or causing a fear of offensive physical contact with a patient or other individual. Battery is unlawful touching of another person without consent. So, for example, if a patient said, I'm going to come over there and kick the snot out of you, that would be assault. Now, if the patient came over there and began to kick and punch you repeatedly, that would be battery. Abandonment. Terminating patient care without making sure that care will continue at the same level or higher. This means that if you went to a scene and you evaluated a patient and you left, if you didn't do, or if the patient wanted to go but you did not take them for whatever reason, then that could be classified as abandonment. Negligence is a deviation from the accepted standard of care resulting in further injury to the patient. 4 elements must be present to prove negligence. There must have been a duty to act. The healthcare professional breached that duty. Injury and/or damages, physical or psychological, must have been inflicted, and the actions of the healthcare professional caused the injury or damage. Proximate cause. What this means is, for example, you went and picked up a patient out of a motor vehicle collision, and instead of properly immobilizing them, you decided to walk them out of the vehicle and into your ambulance. If that patient suffered a cervical vertebrae fracture of any kind or any other vertebrae fracture of any kind, then you would be found to be negligent. And that is because you responded to that scene, so there was a duty to act. You breached that duty by not performing those standards, by not utilizing proper immobilization techniques. And an injury occurred, which is the fractured vertebrae, which is a piece of your spine, and the action of you not performing that duty caused that injury. Duty to act may be a formal contractual duty or an implied duty. A legal duty to act may not exist, but a moral or ethical duty to act may exist, and this is something that you may need to deal with. For example, in Kentucky, you are not required to stop and assist a patient if you are off duty. You may feel a moral or ethical compulsion to stop, and that is between you, your morals and ethics, and your employer. Some employers will allow you to operate under the auspices of the medical director you work for. Some may not. However, when we are talking about a formal contractual duty to act, this is particularly when you are on shift. For example, if it is 6:58 and a run comes in and you get off shift at 7, if you choose not to go on that run and there is no crew there to relieve you, you are breaching that duty to act because you are formally contracted to respond to that run because that is within your shift. Breach of duty is performing skills or treatments outside your scope of care can lead to a breach of duty. Breach of duty may be proved if you fail to act or you act inappropriately. For example, if you attempted to start an IV and a patient developed phlebitis, Well, IVs are outside of the scope of practice for an EMT. Damages. Damages occur if the patient is injured either physically or psychologically by your breach of duty. For example, the phlebitis, which is inflammation of the veins, came from your IV access, which was outside of your scope. So you breached that duty and you caused damages. Proximate cause. Proximate cause is established when your action or inaction was the cause of or contributed to the patient's injury. You could reasonably foresee that your action or inaction would result in that damage. If we go back to the car accident analogy where you walked a patient out of a car accident to your stretcher, while no, you did not cause that vertebrae to fracture, you did not prevent further damage by performing appropriate immobilization. Therefore, you contributed to that patient's injury. And this was something that you could reasonably foresee that your action or inaction would result in. Protecting against negligence claims. Maintain a professional attitude and conduct. Provide skills and treatment within your scope of care. Maintain mastery of your skills. Participate in CE and refresher programs. Follow instructions provided by medical oversight authority. Follow standing orders or protocols. Provide patients with a consistently high standard of care. And make sure your documentation is thorough and accurate. Some things you'll hear us, me or several of your instructors say is if you did not write it down, it did not happen. So it is imperative to make sure your documentation is impeccable. And a professional attitude will go a long way, whether you're on the stand or whether you're dealing with your patient or for whatever reason. Professional attitude will go a long way. And a thorough knowledge of your profession will be to your benefit. If you are forced to go onto the stand, one of the things that the prosecuting attorney may attack is, by attacking your credibility, is attacking your knowledge. They may want to see if you know the things that a standard EMT would know. Health Insurance Portability and Accountability Act, HIPAA. This is an act that provides patients with control over their health information, sets boundaries on use and release of medical records, and ensures the security of personal health information, as well as establishes accountability for medical records use and release. Under HIPAA, you can only release medical information to the patient. You cannot release it to patient's family unless they have specific documentation saying so. And you are able to release it for means of continuity of care, which means when you transport your patient to the hospital, you can release that information to the hospital for the purpose of continuing that patient's care. And you can also release it to your billing agency to ensure that bills are sent to the appropriate places such as Medicare, Medicaid, or your patient's insurance. PHI, this is a term you will need to become familiar with. It's protected health information. And this is information that relates to an individual's physical or mental health treatment or payment, identifies the individual or gives a reasonable basis to believe that the individual can be identified, and is transmitted or maintained in any format. You often hear PHI referred to as identifiers, things that can particularly identify a patient. For example, patient's name, date of birth, social security number, things along those lines. You must keep patient confidentiality. Any medical history given to you in a patient interview, any findings you may discover during your patient assessment, and any care that you provide must be confidential. You can't release this to anybody. Now you may say, well, I've heard Keith talk about several different runs that he's been on in the past. Well, it's okay to speak of specific runs without using patient identifiers. as long as it's not reasonable for other individuals to know the person that you're talking about, you can utilize that information for clinical perspectives. Situations in which patient consent authorization to release of PHI is not required. This means that you are allowed to release PHI for specific reasons, and those reasons are when you're required to, by law, to provide this information. For example, this information may be subpoenaed, your PCR may be subpoenaed for public health activities such as injury and disease control and prevention. There are specific diseases that are tracked by the Center for Disease Control, and it's required as a mandatory reporter to report those illnesses. When the patient is a victim of abuse, neglect, or domestic violence, you are, again, as a mandatory reporter, you're required to report that information. For judicial and administrative proceedings, again, if that information is required to by law. For specific law enforcement purposes, again, this becomes a gray area because patients are not law enforcement is not necessarily privy to HIPAA information without going through the proper channels such as subpoenas. However, it's important to maintain a good working relationship with law enforcement. So, what is the right answer? Well, I can't really give you a 100% right answer. It's important for you to develop that answer on your own based off your policies and procedures for the agency that you work for. And lastly, to avoid a serious threat to health or safety. You may discuss your patient's medical condition, the treatment you gave, and the patient's health information with others involved in the medical care of that patient. This means if you needed to call for an ALS assist, you can discuss the patient information with the crew that responded. However, when you go back to the station, it is not necessary for you to go and tell the other crews who did not respond to that scene and did not play a role in that patient's care about that patient. Medical identification insignia. They're used to alert others of a particular medical condition that the patient has, maybe a bracelet, a necklace, or an ID card. You may see them. You may see or have heard them referred to as medic alert. They may have a specific symbol on them, and on the back it'll have information such as allergies, diabetic, may have a phone number to call with an ID number. And this information will help you treat your patient appropriately. PHI is, we've already been over that. Special reporting requirements. As a mandatory reporter, you're required to report any cases of child abuse, elder abuse, spousal abuse, and infectious disease exposure. There are proper channels. If you look in the Kentucky State Protocols, they have a phone number for you to report child abuse, elder abuse, and spousal abuse. As far as infectious disease exposure, you should follow the procedures set forth by the health department and your emergency management plan. Mass casualty incidents. Mass casualty incidents are incidents where the patients outweigh the resources that are available for the service you employ, or you're employed under. This means when you have multiple patients and you do not have enough personnel, equipment, or whatever is available to properly manage this scene. In which case, you may be tasked with the idea to determine who needs to be transported first and who can wait for transport, or who may not benefit from a transport and may die soon or within that transport.